Blakey and myself, we represent the appellants in this matter. Excuse me, Leslie Dunn Harjan, David Dunn, and Stephen Dunn. This case
Would you like to reserve any rebuttal?
Oh, yes, sir. Yes, sir. I'm sorry. I would like to reserve 2 minutes.
How many? Two. Okay, great. Thank you.
Thank you, Your Honor.
You may
Thank you,
proceed.
Your Honor. Your Honor, this is a case of will construction. At its heart is the question of whether or not the testator intended to disinherit his children. Our clients, Stephen Dunn, David Dunn, and Leslie Dunn Harjan are the children of the decedent Jerry Anthony Dunn. To get to that question, I think that it is necessary that the court take a look at the will as a whole. What we are dealing with, however, specifically within the will, is Article 4. Now, Article 4 of said will says, I give, devise, and bequeath solely to my wife, Beverly Ann Dunn, my farm located on Deadfall Road, Arlington, Tennessee, for her to dispose of as she deems proper, and to distribute some of the proceeds to my children, Leslie Dunn Harjan, David Dunn and Stephen Dunn, and to my stepchildren, Robert Logan and Angela Logan Pickett. It is necessary that when examining a will, particularly in terms of determining whether or not there was an intent of the testator to disinherit his children, to look at the entire will, examine all the provisions. And I will say this. There are 3 gifting provisions in this will. The provision I just read is Article 4. Article 2 gives the party's home place and the possessions therein to Beverly Ann Dunn, who is the appellee in this case. Article 3 gives and devises to Beverly Ann Dunn the balances of any old bank accounts and financial accounts. This will was not prepared by a lawyer. It is not known exactly who prepared it, but it is not believed that this will was prepared by a lawyer. In all probability, it was prepared by Mr. Dunn himself. It is necessary then to determine, under Tennessee law, whether the requirements of disinheriting children have occurred. And the law in this state, as I certainly understand it, is that there are 2 ways to do it. One, you can specifically disinherit, to wit, I disinherit my children, or you can do it by implication. Well, that's what we have here is neither one of those circumstances. The children are specifically mentioned, and I will say this. I'm unaware of any Tennessee case where there's been a disinheritance by implication where the children are named. And here we have...
Why do we have to look at this as a disinheritance?
Your Honor, it's a de facto disinheritance.
It mentions the children, and it provides that they get some proceeds.
That is my position exactly. I'm saying that they are deserving of some proceeds. My position is that that provision, this Article 4 provision, creates a trust, which the children and the stepchildren...
It doesn't mention a trust.
Your Honor, it doesn't have to specifically mention a trust. I mean, a trust can be put together under the terms of the...
When you use trust, I'm thinking about the formal structure of a trust.
Yes, sir, I understand that. I understand that. But I think you can have a testamentary trust without the use of that formal wording. Because what we have here, and you have to read this sentence, or you have to read this Article 4 as a whole, first of all, it's one sentence. There is a word right in the middle of it, and the operative words are that Beverly Ann Dunn was to dispose and distribute. Now, it does say dispose as she deems proper, but I would say that's an administrative requirement.
How can it be given, devised, and bequeathed solely to his wife, and for her to dispose of as she deems proper? The rest of it sounds to me like that's something that sounds like hope.
Well, Your Honor, if that
like
provision,
I hope you will give something to my children. I hope he will give it to me.
Well, all right, two things. First, I think you have to read this as a one sentence. And the word "and" is a conjunctive word. So therefore, the instruction is to dispose and distribute. It's one thought, not two. Now, if you want to talk about this as being a hope, I would argue that this is an instruction to distribute. I mean, if it's a hope, it's precatory. And I do not believe that's precatory because hope is a suggestion. What we've got here is an instruction to, as I said, dispose and distribute.
It seems to me, at the best, it's ambiguous.
All right, Your Honor, in that case, Your Honor, I would agree.
The court has interpreted it to mean that if he divides and bequeaths solely to my wife, and for her to dispose as she deems proper, that...
Your Honor, that's parsing the sentence. That is parsing that Article 4 sentence. You have to read it as a whole, because the instruction is to dispose and distribute. And is a conjunctive word. Grammatically, it ties all this together. You've got to look at it as a whole. If that sentence had simply ended, for her to dispose of as she deems proper, period, that would be it. I would agree, that would be it. But that's not what we've got here. And we've got to look at this document to determine whether or not that there was an intent of the testator to leave his children out.
Well, let's assume just hypothetically that for the sake of argument, that it was setting up some sort of a trust.
Yes, ma'am.
Let's say that their children were deemed to be benefited in some way. You have language where, looking at, again, the whole sentence, but I'm going to focus in on just one part of it, distribute some of the proceeds. Well,
I would agree. Some is a problematic term.
I mean,
But-
some could be $5, some could be, if there's, depending on what this property is worth, $50,000 apiece.
I would argue that if she's a trustee, that she has a fiduciary duty to make a distribution that, well, let me back up. I think that in Pritchard's on Wills and Estates, when you have an ambiguous term like this, where some is not clearly defined, that the law requires the intestate distribution, the rules of intestate distribution be imposed on it. So what we have here, some means a five-part distribution because there are 5 heirs.
But 2 of those people would not be his intestate heirs, correct?
Well, it's a matter, it's not that they become intestate heirs. It's not that, because it's not an intestate situation.
Exactly, but you're saying
But I'm
apply-
saying that the interpretation would be as if. It's not.
So treat that as
It's
if-
not making them intestate heirs, it's treating them as if they were intestate heirs.
So 5
It's
ways.
treating this situation.
So
as
split
if-
it 5 ways is
Yes,
what
ma'am.
you're saying?
Yes, ma'am.
Okay.
Why is this all not premature?
I'm not sure I understand your question,
Well,
Your Honor.
I mean, the language is pretty straightforward. He's giving it to his wife for her to dispose of as she deems proper and distribute some of the proceeds to my children. Doesn't impose any time period for her to dispose of it.
I would argue, Your Honor, that she's a fiduciary, and a fiduciary must act within a reasonable period of time.
What did the trial court say about that?
The trial court did not take that up. That's not, the trial court's order did not deal with that argument. The trial court's order essentially ended
what
on deems
you're-
proper and rejected that argument.
So,
More or less
assuming-
an application.
Assuming I understand your argument correctly.
Yes, sir.
Then are you saying that there is a duty on her to dispose of this property now?
Yes, sir, I am. Because this
Well,
establishes
didn't
her
he give
as
it
a
to her?
trustee. Now, it's part of the problem here is that this will was not put together by a professional, and you've got to impose the rule of liberality in the interpretation. Otherwise, I mean, there are two interpretations here. Either one, it all goes to Beverly Ann Dunn, and these children who are completely left out, they are disinherited, or this is a trust and they get some. The direct statement of the testator in this is they are to get some. Why name them otherwise? And if you look at the will as a whole, you look at Articles 2 and Article 3, the gifting language is almost identical. But what's not there are references to the children. It would have been very simple, either say, all to wife, I'm dying, or I disinherit my children. But here they are, and that's got to be given some meaning. Because if they're not, there's no reason for them to be there unless he intended for them to have some disposition of his estate. Well, it's very simple. Our position is that this article establishes a trust, that Beverly Ann Dunn, as trustee, has a duty to make a disposition of the property as a fiduciary, and then evenly distribute that money to the named parties, the 3 children and the 2 stepchildren. That's all I have to say at this point, Madam.
Thank you.
Good morning, Your Honors.
Morning.
My name is Holly Brewer Palmer, and I am an associate attorney at Williams McDaniel in Memphis, Tennessee. I am here on behalf of the appellee, and that is Beverly Dunn. She is the surviving spouse to our decedent in this matter, Jerry Dunn. Obviously, as you know, the core issue in this case is Article 4 of the last will and testament of Jerry Dunn. There is one rule of construction that I think should be your focus in this case, and that is that every grant or devise of real estate shall pass all of the interest of the devisor unless the intent to pass a lesser interest shall appear by express terms or necessary implication. Think about the power of that rule of construction. Every grant or devise of real estate shall pass all of the interest of the devisor unless the intent to pass a lesser interest shall appear by express terms or necessary implication. This will says, I give, devise, and bequeath solely to my wife, Beverly Ann Dunn, my farm located on Deadfall Road. The next rule of construction says, if the expression in the will is doubtful, the doubt is resolved against the limitation and in favor of an absolute estate. Pritchard's on Wills even talks about the rule of construction that favors granting that entire interest as opposed to trying to read a lesser interest when ambiguous or confusing language appears afterwards. What's our language that we're in dispute over? For her to dispose of as she deems proper, and to distribute some of the proceeds to the 5 children. But you cannot have the latter portion of that article cut down the very clear devise in fee simple of that farmland. I give, devise, and bequeath solely to my wife Beverly Ann Dunn, my farm located on Deadfall Road, for her to dispose of as she deems proper. That is not an instruction to dispose of it. It is for her to dispose of as she deems proper, with the meaning of dispose being a gift, or for her to dispose of it in her own last will and testament, or for her to dispose of it by selling it. And as a precatory request, Mr. Jerry Dunn asked that his wife give some of the proceeds to the 5 children if her manner of disposing of the property was to sell it. It's a precatory request. It's a hope. It's an expression that Jerry wanted to put in his will as a message to his wife, that after he gave her the property in fee simple absolute, if she chose to dispose of it by selling it, he asked as a precatory request that she give some of the proceeds in her discretion to the 5 children. I think it's important to note that not only is my opposing counsel asking you all to ignore, I give, devise, and bequeath solely to my wife. He's asking you to ignore that. He's asking you to put more weight on the latter part of that sentence. He's asking you to impose a trust, and that trust, who are the beneficiaries? Not Beverly. And so now you're going to run into another rule of construction that will be problematic for his position. And that rule of construction is that every word has meaning, that you look within the 4 corners of the will and you try to glean his overall intent. So his overall intent that opposing counsel puts forth before your honors is that Mr. Dunn actually conveyed to everyone other than his wife any interest in one of the most significant properties that he owned. That is a contrary intent to the entire will as a whole. If you look at the 4 corners of this will, you will see in Article 2, Article 3, Article 4, I give, devise, and bequeath to my wife. I give, devise, and bequeath to my wife. I give, devise, and bequeath to my wife. But under opposing counsel's interpretation of Article 4, she gets nothing. She's not a beneficiary of this trust that he wants you to find in Article 4. I'd also like to highlight one more thing. Opposing counsel relies on the McDonald case, where he talks about resolving any ambiguities in favor of not disinheriting a child. I think it's important to note that the rules of construction that were at play there were different. The rules of construction at play in the McDonald case were the rules of construction dealing with disinheriting your children and the rules of construction by dying partially intestate. And where you have those issues competing against each other, those rules of construction competing against each other, the court did say that if there's a question as to whether or not the will did not encompass all of the property, that ambiguity should be resolved in favor of not disinheriting the children. That's not our rule of construction here. Our rule of construction is we favor devises in fee, simple, absolute, subject to clear intent otherwise. And it's our position that Mr. Dunn very clearly in this will as a whole intended to disinherit his children from his estate. I ask that you uphold the ruling of the trial court. I ask that you find that the property located at Deadfall Road was conveyed to Miss Beverly Dunn in fee simple absolute. And I ask that you find the remaining language as a precatory request which is a common phrase in estate planning. Thank you.
Thank you.
Yeah, I'm just going to say a few things. To reach council's conclusion, you've got to parse this sentence. It is one sentence and is a conjunctive word. It has to be read as a whole. If you are going to set up a trust, you are going to devise the trust assets to the trustee. That's what this does. This was done by a non-lawyer. If his intent was to leave out his children, he should have said so. He didn't say so, and he didn't leave them out. The rule, again, is that there are two ways to disinherit children, either directly or by implication. This is neither one of those things. They simply have said, I leave everything to my wife, period. Just as he did in Articles 2 and Articles 3. But if you look at the will as a whole, why is Article 4 different? Article 4 references the children. It is clear, it is crystal clear, reading this document, that Mr. Dunn intended his children to have a portion of his estate. He leaves everything in Article 2 and Article 3 to the wife. He makes an additional gift to Ms. Dunn's children, his stepchildren. It is a very generous distribution, admittedly, but he is not leaving his children out. And the law puts requirements on not leaving children out. You've got to be precise on it. And this is not precise, and I think that you have to resolve that imprecision in favor of the disinherited heirs. Thank you.
Thank you. Thank you, counsel. We appreciate your argument. We will review the briefs, record, and will endeavor to get you an opinion as early as possible. That will conclude the call of the docket for this morning. We'll be in recess to the call